Welcome to the deep dive. We're continuing our journey through the U.S. patent system, looking closely at the MPEP, the Manual of Patent Examining Procedure, basically the examiner's handbook.
Exactly. And, for anyone dealing with patents, getting a handle on the MPEP is pretty crucial for getting through examination smoothly.
Today we're diving into Chapter 2100, Patentability, and really zeroing in on Section 2111. That's all about how the USPTO interprets patent claims using this principle called Broadest Reasonable Interpretation, or BRI.
Right, BRI. And the main thing to grasp is that the USPTO initially casts a very wide net when reading your claims. Understanding BRI helps you manage how wide that net actually is. It really shapes how examiners view the scope of your invention.
Okay, Broadest Reasonable Interpretation, BRI. Let's unpack what that actually looks like. How does it work?
So, at its heart, BRI means that during the examination phase, the USPTO gives the terms in your claims the broadest meaning they can reasonably have. And that's based on your patent application's description, the specification, and importantly, how someone skilled in that specific tech field would get it.
So it's not just grabbing a dictionary definition then?
Oh, definitely not. The reasonable part is key.
Yeah.
It's always tied back to how you describe the invention in your specification. Examiners have to look at that description to understand the potential scope of your claim language.
And this is different from how claims are interpreted later on, say, if a patent gets litigated in court.
Precisely. Think of it like this. During examination, the goal is finding potential clashes with existing text, so they take a broader view.
Makes sense.
In court, however, it's about enforcing a granted patent against a specific product or process. So the interpretation tends to be narrower based on a whole developed legal record, including, the back and forth during examination.
Right. So why does the USPTO use BRI? What's the thinking behind that approach?
The main idea is really about promoting clarity and efficiency early on. By using BRI, the USPTO tries to pin down the invention's boundaries while the application is still under review.
So it pushes applicants to be clearer.
Yes, exactly. It encourages applicants to be really precise with their claim wording from the get-go, or to amend their claims if that initial broad interpretation is wider than what they actually invented or intended. It's like catching potential problems early.
Getting everyone on the same page before the patent is granted.
You got it. And this early clarification, well, it can save a lot of time and effort down the road for both the applicant and the USPTO. It just leads to a more solid examination.
Okay, you mentioned a case earlier, in Prater. How does that fit into why BRI is so important?
Prater. It's a great example because it shows that if your claims aren't clearly tied to a machine or specific apparatus, BRI might allow an interpretation that makes them seem like, well, just an abstract idea or even a mental process.
Like thinking.
Pretty much. In Prater, the claims were about analyzing spectrographic data. But because they didn't explicitly require a machine, the USPTO, using BRI, said, hey, this could arguably cover someone just doing these steps in their head.
Even if that's totally impractical without a computer.
That's the point, because the claims allowed for that broad, though maybe unlikely, interpretation based on how they were written. The rejection stood. It really hammers home why you need to clearly ground your claims in technology.
That makes a lot of sense. So the actual words you pick are critical. Do they usually just get their normal everyday meaning?
Generally, yes. That's the starting point. Claim terms are typically given their ordinary and customary meaning, specifically how someone skilled in that particular technical field would understand them. But, and this is important, there are exceptions.
Okay, exceptions like what? What overrides that ordinary meaning?
Well, the first big one is when the applicant basically acts as their own dictionary, their own lexicographer. Meaning, if you clearly define a term right there in the specification, your patent's description, and you state that this specific definition is the one you intend for the claims, the examiner has to use your definition, even if it's, different from the common usage.
So if I invent, say, a new type of widget, and I write in the description, for this invention, blue means round, the examiner uses round when they see blue in the claim.
Essentially, yes, provided it's absolutely clear and unambiguous and you use it consistently. The idea is you're defining your terms for your specific invention.
Cut it. Clear definition. What's the other exception?
The other way is through what's called disavowal. This is when you, the applicant, unmistakably rule out a certain interpretation of a claim term.
How does that work?
If you make statements in your specification, or maybe even during prosecution, that clearly and deliberately exclude a particular meaning or scope for a term, then the examiner won't apply that excluded meaning under BRI.
So if I write, This device is never made of plastic. Even if the claim just says a housing, the examiner shouldn't interpret housing to include plastic.
Exactly. Assuming that statement is a clear intentional limitation. It has to be an unmistakable disavowal, not just describing one version that happens not to be plastic. You're actively defining away a potential meaning.
Okay. This makes me think of that Phillips v. AWH court case. How does Phillips play into this whole plain meaning versus specification definition thing?
Right, Phillips. It's a landmark case for claim construction, mostly focused on court interpretation after a patent issues. But its principles definitely influence how the USPTO thinks about the specification's role, even during BRI examination.
So what did Phillips emphasize?
Phillips really drove home that the specification is the #1 resource for understanding claim terms. It's the context, it explains the invention, it might even define terms. The court said the specification is often the best guide, sometimes even decisive.
So even though BRI aims broad, and we shouldn't just import limitations from the examples into the claims willy-nilly, the spec is still the key to figuring out what the claim words mean in the first place.
Precisely. The specification is your invention story. It provides the context. Phillips stressed that someone skilled in the art reads claims through the lens of the specification. Sometimes the spec can be so clear about a term's meaning, it essentially overrides a potentially broader plain meaning.
But you still have to be careful, right? You don't want to accidentally limit your claims to only the specific examples you showed.
Absolutely. That's a super important tightrope to walk. Unless you've explicitly defined a term, narrowly or clearly disclaimed broader scope, your claims should generally cover more than just, say, your preferred embodiment. The claims define the invention's boundaries, not just one way to make it.
Okay, let's walk through the examiner's process. When they're faced with a claim term, how do they decide its meaning under BRI? What are the steps?
Well, the MPEP gives them a path. First, they check, does this term have an ordinary and customary meaning in this specific field? If yes, that's the meaning they'll use under BRI.
Unless?
Unless, like we just discussed, the applicant provided a special definition in the specification or clearly disavowed that ordinary meaning.
Okay. And what if there isn't a clear ordinary meaning, or maybe it's ambiguous?
Right. In that situation, the examiner applies BRI in a way that fits how someone skilled in that art would understand it after reading the whole specification. They dive into the description, the figures, the examples to figure out a reasonable, broad interpretation that's consistent with the disclosure.
You mentioned INRI Buzzard before. How does that illustrate the limits? What's not reasonable under BRI?
Yeah, Buzzard. In that case, a claim mentioned flexible foam. The board reviewing the patent decided this could include crushed, rigid foam. Basically, foam that started rigid but got crushed. But the court, the Federal Circuit, said, hold on. They found that interpretation wasn't reasonable. Someone skilled in foam technology wouldn't normally consider crushed, rigid foam to be flexible foam in the context of the invention.
So BRI has to be broad, but it can't be like illogical or completely detached from how people in the field actually use the terms?
Exactly that. It must be grounded in reason and the understanding of a person skilled in the art, a posita. An examiner can't just pick the absolute widest dictionary definition if it makes no sense in context. It needs support from the spec and the field's understanding.
Got it. Now let's switch gears slightly to those small but mighty words and claims, insisting essentially of, I know these are huge for claim scope. Can you break those down under BRI?
Absolutely critical terms. These transitional phrases dictate whether a claim is open, closed, or somewhere in between regarding additional elements. Let's start with comprising. Comprising is generally interpreted as open-ended. Under BRI, a claim using comprising means the invention must have at least the listed elements, but it doesn't rule out other unlisted elements being present too. It's inclusive.
So a device comprising X and Y could still cover a device that has X, Y, and Z.
Generally, yes, because comprising leaves the door open for more components or steps.
Okay, what about consisting of? Sounds much tighter.
It is. Consisting of is closed. Under BRI, a claim using consisting of means the invention has only the listed elements and absolutely nothing else, no extras. It's exclusive.
So a composition consisting of A and B means just A and B, period. No C allowed.
That's the standard interpretation. If C is there, it's typically outside that claim scope.
And the middle one, consisting essentially of, that's the compromise.
Exactly. It's the hybrid. Yeah. Consisting essentially of allows for additional unlisted elements, but only if those extras don't materially change the invention's basic and novel characteristics.
So it might allow for, say, trace impurities or minor additives that don't really affect how the core invention works.
That's a good way to put it. The key question under BRI is whether any extra stuff would fundamentally alter the invention's essential nature or function. The examiner has to assess that material effect.
Okay, lastly, the MPEP isn't static, it gets updated. Have there been any recent tweaks or changes related to Section 2111 or claim interpretation that we should know about?
Yes, definitely. The MPEP is always evolving with case law. If you look at the recent change summary, the MPEP 0005 change-summary.pdf, you can spot some updates.
Like what?
Well, for instance, Section 2164.08, which deals with interpreting those means plus function claims, now cites and discusses a 2023 case, United Therapeutics Court v. Liquidia TechSync.
Okay.
This shows the USPTO incorporating recent court decisions on how to handle specific types of claim language directly into their guidance for examiners.
And I noticed something else in that summary. Section 2164.08 apparently removed a citation to Phillips v. AWH Corp. That seems noteworthy given Phillips is so fundamental.
Yeah, that is interesting. It's subtle. While the core Phillips ideas about using the specification are still vital and are discussed elsewhere, removing it from that specific section on means plus function might signal a slight nuance or shift in applying that specific case to that specific type of claim. It just highlights how interpretation guidance gets refined.
And there was another case mentioned, Clarone.
Right, Clarone Inc., V-Sure Acquisition Holdings Inc. That's been added to Section 2173.02, which is about claim definiteness, basically, whether claims are clear enough.
So that suggests more focus on clarity.
Exactly. It shows the USPTO is keeping pace with court rulings on what makes claim language clear versus ambiguous. Unclear claims are hard to interpret, even under BRI, so this update gives examiners more current guidance on that front.
So the takeaway is that even the MPEP rules themselves are a moving target to some extent.
Precisely, which is why practitioners really need to stay on top of these updates. It's crucial.
This has been incredibly helpful, a real deep dive into MPEP 2111 and BRI. It's abundantly clear that understanding broadest reasonable interpretation is fundamental for anyone involved in U.S. patent prosecution.
Absolutely. The key things to remember are BRI seeks the broadest reasonable reading. It's always grounded in the specification and a skilled person's perspective. And your specific word choices, like those transitional phrases, they really matter a lot.
And while we've covered a lot, this is really a starting point for understanding this complex area.
Definitely. For the definitive word, you always need to consult the official MPEP itself or get guidance from qualified instructors or registered patent practitioners. And yes, keep watching for those updates.
Absolutely. And we absolutely want to give a sincere thank you to Mike Shepard. He's the creative director who really made this whole series possible.
And just the necessary reminder for everyone, this summary used AI tools in its preparation, and it's purely for general educational and informational purposes. It might have errors, and it is definitely not legal advice. Please consult a professional for specific situations.
So, to leave you with something to think about, how might just one seemingly small word choice in a patent claim dramatically change how an examiner sees it under BRI and maybe alter the entire course of examination? It's something worth mulling over. Thanks for joining us for this deep dive.